Welcome to Set Yourself Up for Success, setting expectations and establishing good client screening. My name is Roya Samargandhi, and I'm an attorney based in Chicago, Illinois, and the founder of Carmel Law, LLC. My firm provides legal services aimed at modest income individuals in Chicago and the surrounding areas. I practice in all areas of family law, from divorce and custody to adoptions and Department of Children and Family Services appeals. I also represent criminal clients and parties to orders of protection. Today we're going to touch on a number of topics, including the importance of creating a conflicts check system, how to successfully screen clients and scope cases, and how to set expectations for those clients you do engage to establish not only a successful attorney-client relationship, but a successful practice more broadly. Prior to launching my firm in 2015, I practiced in corporate transactional law, where I truthfully was blissfully ignorant of many of these issues. But as I started my own litigation practice, making sure I was working with the right clients became of paramount importance. Trust me when I say it was a steep learning curve for me. However, with the information set forth in this course, I hope that you're able to bypass some of the mistakes I've made along the way and set yourself up for success moving forward. Let's get started. First, take a moment and consider how many of these situations you can relate to. My client calls me 3 times a day and is driving me crazy. My client stopped paying me and now I'm working for free. This case is killing me. I don't even do family law, but I took this case because I needed the money. Or how about, my client has unreasonable expectations and is impossible to satisfy. Screening clients, scoping cases, and setting expectations are arguably the most important elements for setting a lawyer up for success. Attorneys can have a good business model and pricing menu, but still fail because they fall short during this stage. You've got to get these parts right. First, let's take a moment to think about a conflicts check system. Implementing a conflicts check system is one of the most important things you can do, and it'll prevent a lot of headaches for you down the road. Let's consider what a conflict of interest even means. Conflicts of interest can exist on a number of fronts, from concurrent clients, meaning 2 clients that exist at the same time, or a former client to a concurrent client, third parties, and even you as a lawyer's own individual interests. Now, it should be pretty clear that you can't represent adverse parties in a single matter, but other situations might not be as clear-cut. Perhaps you have a personal or even a romantic relationship with a potential client. A little practice tip from me to you: if a friend or a family member comes to you for legal representation, refer them. And in fact, you should be mindful that a lot of jurisdictions and states have express prohibitions against having a personal, romantic, and/or sexual relationship with the client. Another example is a conflict between a former client and a current client. I've had paramours, boyfriends or girlfriends of former clients, come to me for their own family law matters. In such cases, while not always a bright line conflict of interest, there's sufficient enough of a concern for me that a conflict could exist or arise, that it's a situation I choose not to involve myself in. In such case, I leverage my network and try to provide appropriate referrals for that individual to get them to someone who might be able to assist them. For more information about conflicts of interest, I encourage you to review the specific ABA model rules, including Rule 1.7, 1.9. For more information, I encourage you to review the specific ABA model rules, including Rule 1.7, 1.8, and 1.9, as well as Model Rule 1.18, which specifically deals with prospective clients. More than likely, the same or similar rules have been adopted by your local jurisdiction or state.